We are given the responsibility to carry out a sales project as one of our assessments for business law. This end of chapter will be carried out at Polytechnic Kuching Sarawak campus. This end of chapter is conducted to enable us to implement the theories that we have learned in business law course into our daily life. Our group Anak Rasa announcing on our selling of business product and acquiring agent in others to perform the business transaction.
Assalamualaikum. I, Awang Luqmanul Hakim bin Awang Suhaimi from the 82A will present Termination of Agency under Contract Act 1950. Definition termination of agency. First, an agency that have been existed can be terminated in different of ways. Second, termination means the ending of the contract of agency between principal and agent. And third, agency can be terminated in one of the following ways, like by agreement, by performance, by the principal revoking the agent's authority, by operation of law, by the agent's renunciation, and the last one, by frustration. By agreement, when both parties desire and agree that the agency shall terminated, the agency is terminated. In this case, Anak Rasa owners agree to the total termination of the agency. In this method, both the principal and agent can agree that the agency is to come to an end. If the agency is evidenced by a contract, then any provisions regarding the termination should be observed by the party wishing to terminate the agency. Reasonable notice must be given, depends on the facts and circumstances. By the principal revoking the agent's authority. The principal may revoke the authority of the agent at any time before it has been exercised to bind the principal. The principal can revoke the agent's authority where, first, the principal give notice to agent, and the second one, the agent is in default under the agency. However, the power to revoke the agency by the principal is limited to Section 55 of the Contract Act. The agent has an interest in subject matter. For example, Anak Rasa want to sell the potato ball, but at the same the agent want to buy or have interest on the potato ball. By performance. According to Section 155 Contract Act, the contract of agency is ended when the agent has performed the contract. This can happen when agency is created for a single specific transaction and the transaction is completed. And I will pass the next presentation to Damien.
Very good day to Madam Zuleika. My name is Damien Jemat Lawrence. I will be explaining about real life example or a scenario of termination. First one, by agreement. In this scenario, Sarah ran a small marketing firms and she hired Alex as her sales agents to secure new clients. However, after a few months, Sarah realized that the service provided by Alex aren't yielding the desired result. But on the other hand, Alex feel that the marketing strategies provided by Sarah aren't effective in attracting clients. So in the end, both agree to terminate the agency for the goods of both sides. That is by agreement. Secondly, by principles revoking the agent's authority. For example, here, or in this scenario, Sarah ran a successful e-commerce business selling organic skincare products. She hires Alex as her agents to manage wholesale account and distribution to retail store. The termination by principal revoking authority process can be defined as there is 8 termination authority process. First one is evaluation of performance, identification of problems, discussion with the agents, notice of revocation, transition periods, transfers of authority, closure, and moving forward. What it means by principal revoking the agent's authority is, for example, an agent given full authorities to do whatever you want during the agency or during the contract, but later the owner realized that by doing that, the agents not unable to accomplish a specific task, so the owner take action in revoking the authority to do like selling their products illegally. That is termination by principal revoking the agent's authority. And lastly, termination by performance in a scenario. In this scenario, Sarah owns a retail business specializing in handmade jewelry. She hires a marketing agency represented by Alex to promote her products and increase sales. But Alex's performance was very poor, so Sarah decided to terminate Alex's contract because of his poor performance. By doing so, Sarah needs to follow the termination by performance process. The first one is setting performance criteria. This happened during their signing of the contracts to the agency. And secondly, performance evaluation. Thirdly, review meeting. Fourth, performance assessment. 5, notice of termination. In this context, termination because of a poor performance or doesn't meet the required sales target. And 6, transition period. This is transition period where Alex need to decide to whether he likes it or not. He need to terminate the contracts too. And 7, termination, and 8 is the closure for the agency or the deal. Okay, we move to second question. A1. Define Nemo.Quad non-habit rules. Nemo.Quad non-habit rules literally meaning no one can give what they do not have. It's a legal rules, sometimes called the Nemo.Quad rules, that state that the purchase of possession from someone who has no ownership right to it also deny the purchaser any ownership title. It is equivalent to the civil continental Nemo plus iuris ad ilium transferre potest quam ipset habet rules, which mean one cannot transfer to another more right than they have. 2a, Roman 2. Importance. The Nemo.Quad non-habit rules is a fundamental principle in our business selling transaction because in property transaction, this principle is significant implication. It ensures that a buyer can only acquire the rights that the seller actually has to the property. For example, if someone sells a piece of land that they don't legally own, the buyer cannot acquire legal ownership of that land because the seller lacks the authority to transfer it. This rule protects us as the business owner from unknowingly selling properties to someone who doesn't have the legal rights to buy it. It promotes certainty and stability in property transaction by preventing dispute over conflicts claim of ownerships.
Stop else, where the owner by his conduct makes it appear to the buyer that the person who sells the goods has authority to do so, and the buyer relies on the conduct. The buyer obtains a good title because the owner is precluded by his conduct from denying the seller's authority to sell under Section 267 SOGA 1957. Avoidable title. According to Section 29 SOGA 1957, where the seller of goods has obtained possession thereof under contract of sales voidable under Section 19 or 20 Contract Act 1950, but the contract has not been rescinded at the time of the sale. The buyer acquires a good title to the goods provided he buys them in good faith and without notice of the seller's defect of title. A contract is voidable under Section 19 or 20 Contract 1950 when the consent of the original owner is caused by coercion, fraud, misrepresentation, or undue influence. Sale by mercantile agent. A mercantile agent is a person whose ordinary business is to sell goods or consign them for sale, or to buy goods, or to raise money on the security of goods. According to Section 27 Soga 1957, where a mercantile agent is, with the consent of the owner, in possession of the goods or of a document of title of the goods. Any sale by him when acting in the ordinary course of business of the mercantile agent shall be valid as he were expressly authorized by the owner of the goods to make the same. However, buyer must have acted in good faith and, at the time of the contract of sale, would have had no notice that the seller had no authority to sell. Estoppel. Estoppel is a doctrine that prevents a person from denying a fact that they have previously acknowledged or represented to be true. In the context of selling Anak Rasa's potato ball, if the seller represents to the buyer that they have the right to sell the goods, and the buyer relies on that representation, the seller may be stopped from denying their ownership or the rights to sell the goods. For example, during Commerce Week, a seller, Alex, represents to a buyer, Ben, that they have the right to sell a batch of Anak Rasa's potato ball. Ben realized that Alex's representation and purchases the goods. Later, it is discovered that Alex did not have the rights to sell the goods. In this case, Alex may be stopped from denying their ownership or rights to sell the goods, and Ben may be able to retain the goods. Avoidable title. Avoidable title is a title that is valid until it is avoided by the true owner. In the context of selling Anak Rasa's potato ball, if the seller has avoidable title to the goods, the buyer may acquire a good title to the goods if they are unaware of the defect of the seller's title. For example, during Commerce Week, a seller, Charlie, sells a batch of Anak Rasa's potato ball to a buyer, David. Unbeknown to David, Charlie obtained the goods from a thief. If David is unaware of the defects of Charlie's title, David may acquire a good title to the goods, and the true owner may not be able to recover the goods from David. Market overt. Market overt is a doctrine that applies to the goods sold in the market or a place where goods are commonly sold. In the context of selling Anak Rasa's potato balls, if the goods are sold in a market or a place where goods are commonly sold, the buyer may acquire a good title to the goods, even if the seller does not have the rights to sell the goods. For example, during Commerce Week, a seller, Emily, sells a batch of Anak Rasa's potato balls to a buyer, Frank. At the market stall, unbeknown to Frank, Emily does not have the right to sell the goods. If the market stall is placed in where the goods are commonly sold, Frank may acquire a good title to the goods, and the true owner may not be able to recover the goods from Frank.